No, mine has gotten my son out of a lot of things because she talked to me. I'm like, you're only doing that because it's your grandbaby.
Yeah, if it were you, it would be something different.
Yep.
It's taking forever for my. Sean, one of my friends went to cookie place. And do you know, she said that now somebody's selling their cookies for $5. $5 a cookie.
Where, you know which one it was?
Yes, I do.
Is it in the Alamo Heights area?
No,
Oh, it's not over there by the zoo?
it's cookies that I've ordered before.
Oh, really?
And I'm just like, yeah, I'll make my own cookies.
There's a cookies over there by the zoo. And they're really nice cookies. They're like the decorations on them and everything, really nice. They're
Oh, wow.
well, they're good though. They're good. They're good.
Thanks, you know, I think better about that.
Oh, yeah.
Now, I know your revolution. Are you have any dietary things on food?
No.
Oh, okay.
Please make
I
sure you're
started
going
getting
off or on fire.
beef tenderloin,
Oh, but see, I don't.
big hunks of it.
On fire.
What?
I don't eat meat anymore.
When your name gets
Yeah, so I don't eat meat anymore.
And because I was looking, and the ribeye steaks were like $15 and $16 a pound.
Oh, wow.
gonna do it when he
And I'm saying, you know, I would gag if I tried to eat that.
Yeah. No, I can't. I mean, I will eat meat once in a while, just if I'm at a place where it's real.
For
Yeah.
$11 a pound, though. The beef tenderloin, and all I need is a sharp knife, and I cut it into steaks,
Oh, wow.
and I have filet mignon if I wrap it with bacon.
Oh, well, it sounds like somebody needs to come to your house.
You really, I've been telling you that.
I
for
know,
at
and
least
sit
a
underneath the
decade now.
magnolia tree with you and your wife and drink tea.
We'd even get, what is it? Is it lime or lemon with your Sprite?
Yes, lime with Sprite. You know,
Okay.
Sprite only tastes good if you put lime with it. Coke tastes good if you put lemon with it.
I think Cokes taste good if you put one with them.
If only I drank right.
We tolerate our less fortunate brethren.
Okay, thanks. All right, everyone. Happy Tuesday. Hi. Thank you. No problem. You know, my goal is to drink as much fluids and waters as possible because I take allergy medicine, and when you don't,
Oh, you gotta flush it out.
yeah, you get very dehydrated. So I'm trying not to do that and trying to drink more. So,
Hopefully that can cool you off at the same time.
oh yes, I don't know why they have it so hot in here.
Make us sweat.
Yes. All right, happy Tuesday. I'm going to call the docket. We are starting up a jury trial at 11:30, so everyone needs to be done with everything by 11:15. All right, Manuel Adame is in custody. Raymond Gutierrez, custody. Maricela Cuellar. Maricela Cuellar. Brandon Guzman is in custody.
He's in custody, Judge, we're ready.
Thank you. Travis Murray. Jonathan Boyd. No relation. Aaron Trevino is in custody. Maria Neely, custody. Mark Salcedo, custody. Jose Garcia, custody. Samantha Richards. All right. Juan Ratana is in custody. Philip Diller. Thank you. Cruz Rivas, custody, Brianna Gutierrez. Brianna Gutierrez. Jesus, how do you pronounce that?
Realme, Your Honor.
Realme, thank you. Jesus Realme,
Council President.
thank you. You may want to check with County Court 15. He has a lot of cases in there. I don't know if he's there first. Gloria Roscoe. Martin Martinez. In custody, we have Christopher Cantu. Wilbur Villamil is in custody. Jose Garcia. John Sanchez. Okay. Thank you. Stephen Wilbacher. How you pronounce your last name? Walbarker. I really messed that up. All right, we'll take care of that. Okay, see, people put in everybody's business in the purview, but okay. Joseph Garza. Matthew Cole. Christopher Garza is in custody. Juan Avalos. Demetric Jackson is in custody. Abelardo Torres, custody. Raymond Ruiz, custody. Marcelino Scott. Amanda Villegas. Amanda Villegas, thank you. In custody, we have Luis Mendez. Timothy Hernandez. Juan Orozco Jr. Juan Orozco Jr.
I'm here on that. I've not heard from them. I left a message this morning.
All right.
I'm gonna rent another court.
Yes, you may want to go down the hallway and see if he's at the previous location of the 187.
I think that's where I'm going.
All right, Brandon Sierra. David Leon. John Ramirez is in custody. Is there anyone who's present and your name was not called or you came in late? All right, we'll start here. What's your name?
Not a juror? No.
All right. Do you know who your attorney is?
Yes, Joe Steinberg.
And do you know your SID number or case number?
I did not.
All right, just give us a moment. Yes. All right, just have a seat.
Margarita Lopez,
All right, do you know who your attorney is?
Samuel Lance,
All right, and do you know your case number?
795-689.
All right, we're going to have you approach in just a moment. What's your name?
Vincio Rodriguez,
Do you know who your attorney is?
Ron Rock,
And do you know your case number? All right, what's your SID number?
815-605.
All right, just have a seat. Anyone else? All right, who is this guy holding up the window outside?
Brianna, here in the docket, so talk to the commissioner.
All right. Are there any jurors in the courtroom? If there are jurors for the 187th in the courtroom, you need to wait outside. All right, so any other jurors? All right, so these are the rules of the court. I try to keep the courtroom as least congested as possible. To all the attorneys, if you have a case in this court for your client, just grab a file, place it on the prosecutor's desk, have a seat. They'll call you in the order of appearance. To this side is criminal trial division. To this side is family violence or special crimes. They're going to change their name to something that's more catchy. Criminal trial division sounds like they're in trial every day. So family violence, working on the name change. All right. And then do not approach the court unless you've spoken to your client, spoken to the state. And if you've got an offer, tender that offer to your client. If you have someone who's in custody, ask the deputy to bring them out. If your client needs an interpreter and you speak their language, you still need to ask for an interpreter because I need to be able to speak to them. Once an interpreter is requested, do not leave the courtroom because there's a shortage of interpreters and they can only be here for a limited amount of time. We're going to be starting jury selection at 11:30. So everyone needs to have everything taken care of by 11:15. If you do not have it taken care of by 11:15, what will happen is you're going to come back tomorrow. Even if you have to be in Del Rio or wherever you have to be, you're going to be in the 187th District Court tomorrow. So today is Tuesday. We're closer to Friday than we were yesterday. So everyone put some patience in your pocket, use it as needed, and it's going to be a great day. Yes, Mr. Young?
I talked to my client.
Mhm.
On the phone.
Okay.
He didn't know that he was set for today. I don't know why I had it down and he didn't.
Okay.
The deal we have is for this case to be dismissed when he pleads to a misdemeanor. And misdemeanor is not set.
Which court is the misdemeanor?
It's set in May sometime.
Oh, wait, which?
It's in 15.
All right, can you go to number 15 and see if they can move that? Because I'm not going to keep this case open till May for a plea.
I understand. Can I bring him back tomorrow? I can't get here today.
Okay, who's your client?
Jesus Realme.
Can I see the file on Jesus Realme, please?
What's the file?
Ah, thank you. No, you know what? He was supposed to be entering a plea in misdemeanor court on December 19th.
And for some reason, we didn't go there that day.
All right. Caroline, can you look up Jesus Realme and see if there's a warrant out?
What was that case?
It's 2022 CR 7470. And I'm trying to figure out the misdemeanor case.
I think you spent the day sometime.
Okay.
Seeing that May date, but I'm not seeing that he has a warrant.
All right. So I'm going to recall this tomorrow, but he needs to do that plea well before May. So I don't know if you are able to talk to County Court at Law number 15.
And I'm not sure I can either because they're currently doing everything on Zoom.
Who is 15?
What's her name? Laura, maybe?
I'm sorry. Who's County Court at Law number 15?
Melissa Barr.
All right. So do you want to go over there and tell them that this case needs to be put? I mean, they'll probably be able to put it on the docket tomorrow.
I'm fully capable of falling on my short draw.
All right. So I'm going to recall this for tomorrow.
And one way or the other, he'll be in here tomorrow morning.
All right. Thank you.
Thank you, Ron.
You're welcome. And your other client?
I haven't had any contact with her.
All right. Do you want me to take that up now?
Can we recall her for tomorrow morning also, please?
No, not if you haven't had any contact with her. What's her name?
Samantha Richards.
She's right there.
Aha.
Yay.
See?
Miracles are happening.
Yep. I think it's-
Could you meet us, please? And everyone, just give me 2 minutes, please. All right, Matthew Cole. All right, thank you. If there are any jurors in this courtroom, you need to step out into the hallway. Nobody reads those signs, Deputy Laura. Yes. You waste, I mean, trees are being killed and nobody's reading the sign. So I'll just make the announcement every 5 minutes. John Young, if you can come forward, please. Judge Vera, she's Judge Vera, Melissa Vera. She said she can take your case tomorrow.
And he'll be here. He will check in with you first, and then we'll go to the minor court.
Okay, all right, thank you.
Thank you, Your Honor.
You're welcome. Who's here on Aaron Trevino? Yes.
Oh,
All right, yes.
Good morning, Judge. I confirm with the state, confirm with my client, and my client would like to have his jury trial.
All right. Let me see what. Oh, your shirt is fitting with Valentine's Day with the
It
roses.
was done on purpose, Judge.
It was done, okay. All right, let me find him on the docket. All right, so what will end up happening is we're going to start jury selection at 11:30. All right. So just make sure you come back by 11.
Yes, Your Honor. I'm gonna go reset other courts, but I'll be here before 11:30.
All right, thank
Thank
you.
you, Judge.
All right, are there any jurors in the courtroom? All right, if you're a juror and you're in the courtroom, you need to wait outside. Good morning. I'm like, where have you been?
Pro 10 case yesterday. Unfortunately, I was in Honda.
Ah, good old Hondo. How far is Hondo from here?
Probably only like 40-minute drive.
Okay. Well, I'm hoping at least you had a chance to enjoy the scenery on the drive.
There's nothing.
All right, thank you. Bashan, can you review this motion and see if you can tell me where he is as far as being placed in inpatient? Thank you.
Dear Pro Chairman,
Yes.
I said, we gotta talk about what's really important, just how beautiful those flowers are.
Oh, well, thank you so much. I appreciate that.
I knew you'd have flowers under
Well, thank you.
it. Secondary, my client exterior, we're working on the plea paperwork, Amanda Diegas.
All right, just let the clerk know.
Okay, she's here, I'm here. I had leg surgery, I was under the weather yesterday, today I'm better.
All right, well, I'm glad you're feeling better.
Thank you.
All right, court is calling 2019 CR 7044A, State of Texas versus Matthew Cole. Can I have parties approach and announce for the record? For the state?
Ruben Herrera for the state.
For the defense?
Austin Navy for Mr. Cole.
All right, so we're starting a new thing in this court. People are not allowed to whisper when they come before the bench so that the court reporter can hear. It amazes me. Everybody whispers when they're before the bench, but then when they're talking and conferring, everybody is so loud we can't hear anything up here. So everyone needs to keep their voices up so that the court reporter can hear. It's Valentine's Day. We're going to make her job easy today. All right.
Yes, Your Honor.
Thank you. All right. So yesterday, the court heard testimony from defense witnesses. Is there any more testimony from either side?
No, the state does have victim impact statement. The victim in this case is running a 3-minute delay charge. They are here parking. We may need just a few minutes.
All right. So, Mr. Cole, I reset this case for today because there are many things for me to think about. And I will tell you from reading the police report, my first thing was you belong in prison. And some cases, they're very difficult. And I never have a crystal ball to know how somebody's future is going to be. So when I'm making decisions about what's in the police report about the person who's standing before me, about whether this person has learned their lesson, because sometimes punishment is about rehabilitation, but it's also about punishment as well.
Absolutely.
And any type of sentencing, punishment is always a part of it. But then you have the rehabilitation. And hopefully when people go to prison, they receive rehabilitation as well. Sometimes it doesn't work out. Sometimes people go to prison and they come out of prison. Sometimes they're worse than when they went in. And sometimes they just don't learn anything. They say, my life is over. So in reading the police report, it's horrible what you did. But I am also looking at, and it wasn't these prosecutors, but previous prosecutors with regards to the co-defendants, they agreed for them to have deferred adjudication. So I listened to your past and what you've gone through with your mom being a heroin addict, with your grandmother having a seizure while you were 8 on the VIA bus, and CPS just coming in, scooping you up. And then they're like, this is your new family who you're going to be with. I, internalized the fact that this person is supposed to be your very best friend. And then it turns out your best friend is not really a friend. He's with the mother of your child.
I knew him since elementary school.
Yeah. So you knew him since elementary school. We can go off the record. As a side note, you know what my grandmother would always tell me?
What?
Nobody's your friend, but Jesus Christ, and sometimes your mom.
So my grandma.
Because sometimes your mom doesn't like what you do. All right. We can go back on the record. So it appears that you're doing well, and you're doing well not being in Bexar County. So is it your intention to remain outside of Bexar County?
Yes, ma'am, absolutely.
All right.
We'd like to transfer, Your Honor.
Okay. So, Mr. Cole, what do you think should be done with you?
I think I should get deferred.
Well, no, here's the thing. Sometimes people think and want certain things, but the question is, what do you deserve?
I think I deserve deferred because I've made a lot of effort and a lot of improvements in my life. And I'm continuing to make those improvements. And I know in my heart that whatever punishment you give me, I'm going to follow through 100%.
So if you get sent to prison, what are your plans?
I'm going to try to have a positive mindset in prison. I mean, nothing much I can do there. Obviously, I'd like to not go to prison. I'm trying not to follow in my dad's footsteps. But if it happens, it happens.
All right. So what would be your plans if you're in prison? All right. If there are jurors in the courtroom, you need to wait outside. And the person in the red coat, you need to have a seat. If you're in the courtroom, you need to have a seat. If you are on the docket and you're late, you need to have a seat on the first row. So if you're sent to prison, what are your plans? Because your minimum sentence going to prison, it's an agreed upon that you do 6 years. So what would be your plans if you're taken into custody today and transported to prison?
My plans would probably be to pursue a higher education, but that would also be my plan if I get deferred. The only difference is I'd be able to work and provide for my family.
All right, because we're talking about prison. We're not talking about deferred. So I'm trying to figure out what your plans are if you're sent to prison.
I would pursue a higher education and work out probably and read.
And how do you think prison life would go for you?
I don't think it would go well. I would just be surrounded by the people that I've worked hard to get away from.
Mm-hmm. And sometimes the people we work to get away from are our people, right? Because if you commit a crime,
Absolutely.
a lot of people will come before me and they'll say, oh, I'm not like them. And my thing is like, yeah, you're like them because that's why you're here. You committed an offense. So
I definitely agree that I used to be like that. But I know that I've changed. And I know I'm a different person now.
but if you go to prison today, that means that you have to say goodbye to your family. Are they going to wait for you?
I believe so.
Have you talked to them about going to prison?
Absolutely.
And
I've
what's your
talked to my wife
conversation?
about going to prison since I first met her.
Mhm.
It's hard, obviously, but I believe it's something we'd be able to work through.
All right. Anything else for me to decide?
I have something briefly, Your Honor. I do think Mr. Cole will do better outside of prison because of the work opportunities he has, the family support he
But doesn't
has.
everybody feel they'll do better outside of prison?
Well, yes, but I think
People who don't people who get sentenced to murder think, you know what? I do better outside of prison.
it's a fair point, Your Honor. Poor choice of words on my part. What I mean to say is, Mr. Cole has work opportunities, has a new baby that's coming, that's not going to be provided for while he's in the system. And I think him working and being with that new family is going to produce generational results. And I think giving him that chance at deferred is the right thing at this moment. Now, if he screws that up, that's on him. And you know the full range of punishment will be there at that point. But I think he deserves one chance at this deferred because he's telling you he's ready. And I think if you give him that chance, he's not going to let you down.
Yes.
And I just want to say, because I haven't been there for my son for so long, I don't want to miss out on the opportunity to be there for my daughter.
But here's the thing, and I always tell people this. These are things that people should have thought about before, right? So
Absolutely.
let's assume you are alone in this world. You don't have any children, you don't have a wife, right? So there's nobody that you need to be out for to financially support.
Yes, ma'am.
Having that as a scenario, why shouldn't I just send you to prison?
Because I still want to support myself. It's not like,
Well, I mean, you can support yourself
Still-
in prison.
you know, like it's about my family more,
Well,
in
no,
my mind, but
let's assume you don't have any family. Let's just assume you are Matthew Cole by yourself in this world. Now, if you get sent to prison, guess what? You're going to get meals.
Yeah.
It may not be the meal you want. You're going to get a shower. There's going to be electricity. I don't know if they do AC at the prison or not. It's been a long time since I visited the prison, but you're going to have all that. So you will have support. You will be allowed to work. You can work in laundry. I think you can work in the cafeteria. They provide free education. So you'll have all those things if you're sent to prison.
I think it's possible that I would fall back into a negative mindset being in prison. I mean,
That's the wrong answer, because you just told me if you were sent to prison that you're going to make the best of it. And when you get out,
yeah,
you
but
are going to do right.
I'm going to be sad about it. Obviously, I'm not going to go into prison like happy and cheery. You know, it's going to be hard. And that's what I'm saying. Like, I think I deserve a chance, and I don't think that prison is the right place for me, for who I am today.
Okay, nobody thinks prison is the right place for them. People who are at the Bexar County Jail who come over here doesn't think the Bexar County Jail is the right place for them.
I think the witnesses from yesterday show that everyone in my life, everyone that I'm surrounded with now, thinks that I shouldn't belong in prison.
But what
And
is
these are all upstanding people who are very law-abiding citizens.
but what does the complainant think?
I'm sorry, I didn't.
What does the complainant think in this case?
I'm not sure. I would be upset, obviously, if I was in that position.
I'm sure the complainant probably thinks you should go to prison, right?
Probably, but I'm not sure. I haven't been able to talk to anyone. I have a no contact order. So.
All right, anything else?
This time we would just re-urge to follow deferred recommendation.
Whispering.
We would re-urge to follow the deferred recommendation, looking at what the co-defendants have done and received, and also in light of what Mr. Nicole said today, and all of the witnesses that are there to support him, I think he deserves that chance.
And how old are you?
I'm 23.
All right, anything from the state? I know you are silent.
We do have a victim impact statement. The complainant in this case is here.
All right. And so this is what the court is going to do. And the court will note that the co-defendants received deferred adjudication. Court is going to sentence you to 10 years deferred adjudication, $1,500 fine, time and money to run concurrent. There's an affirmative finding of family violence. There's to be no contact with Alyssa Garcia and Dalton DeWinnie. That's DEWINNIE. The BIP course. There's to be regular reporting by Zoom or in person. There's to be regular UAs. And where are you saying you want the transfer to?
I live in Renton, Washington,
What county is that?
King County, I believe.
We'll
All right.
confirm.
We'll do a transfer to King County. 300 hours of community service restitution. 40 of those hours we waive if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. Parenting classes. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Anger management. I'm going to want a TAP evaluation. And if the TAP let me see, I think we may have had a TAP evaluation.
I think there was a TAP as part of the PSI. Your Honor.
So I'm going to want intensive outpatient treatment. And I'm going to want 90 sober meetings in 90 days. And probation, can you see if King County, I don't know if they do it, if they can do field visits. If they can do field visits, then I'm going to want field visits 2 times per month. And if they want to, they can make the reporting the field visit. Probation, is there anything else he needs?
Is it okay for him living in King County right now to give him a travel permit to get there and then
Yes,
for virtual recording until he's actually transferred?
yes. All right, anything else, probation?
No, Your Honor.
Mr. Cole, is there anything else you need from the court?
I don't think so. I just want to say thank you.
All right. Well, I mean, we'll see how you do, okay?
Ma'am.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So, Mr. Cole, you need to make sure that you follow through on everything that's being asked of you. If for any reason a motion to revoke is filed against you and it's granted, you're looking up to life in prison. You understand?
Yes, ma'am.
Now, your agreement with the state was for 6 years and they were silent. So because you received deferred adjudication, now you're looking up to life in prison. You understand?
Yes, ma'am.
You're going to have to do better. And from here on out, every decision that you make in your life, you need to ask yourself, is this something that can result in me potentially going to prison for life? You understand?
Yes, ma'am.
And that goes with any marijuana use, any edibles or anything like that. You understand?
Yes, ma'am.
If there is some issues with mental health, then you need to talk to someone about that. And you can speak to probation about that. They will recommend someone. You understand?
Yes, ma'am.
All right.
Your Honor, one question, the 90 sober days, what exactly is that?
Oh, he needs to do 90 meetings in 90 days.
Can some of those be online or does he need to find an in-person facility?
I can go to an AA meeting.
Okay,
Yes.
so in any means, okay.
Yes.
thank you.
All right. And my understanding there's victim impact.
There's your.
Are they present?
They are.
Okay.
You can leave us. And stop it.
on Aaron Trevino. Why do I have the file on Aaron Trevino?
No, I was looking at it.
Oh, okay, all right, sure. Jonathan Bolden.
Good morning, Your Honor.
Good morning. Where is Mr. Bolden?
He was not ordered for today. It was some oversight of the court. I checked with the bailiffs. They do not have him downstairs.
Ms. Ferguson? We need Jonathan Bolden here.
Your Honor, I filed a motion for continuance. He was set for trial. As you will recall, he was the defendant last week that requested the trial as soon as possible.
Mhm.
In my motion, I state that number one, he's homeless. I didn't until last night get his size proposal so he could appear dressed for trial, but I haven't been able to get those to the county jail.
All right, Ms. Ferguson, let them know that Mr. Bolden needs to be brought over dressed for trial. Yes,
All right, Your Honor, do you want me to get the clothing to the jail? I've got some other settings I gotta get Joe.
but where's the clothing? I thought you said he already had the clothing.
No. I got his sizes last night, and then after I left the jail, I was able to go purchase some clothing for him.
All right, yes, you need to bring his clothing. Have him brought over. Do you have the clothing here?
Am I right?
All right, just hold on to the clothing. Have Mr. Baldwin brought over.
I'll go check in with my other question. Thank you.
All right, who's here on David Leon?
Aye.
He said, it shows that he needs a Spanish. He needs an interpreter.
Yes, Your Honor.
All right, we need an interpreter called up. Let them know.
Okay.
All right, and this one's done. Travis Murray.
Your Honor, I'm present.
All right. Mr. Murray, come up. And are there any jurors in the courtroom? If there are, you need to wait outside. Any jurors in the courtroom? All right, yes.
Yes, Judge. We're set for trial in this matter, injury to a child's allegation. It's my understanding the state wants to reach out to the complaining witness, the child, just to verify the contents of the affidavit non-prosecution we had, Judge.
Mhm.
So I believe they just wanted to verify that it is his wishes to not move forward as a witness.
All right, somebody pick up the phone and call.
Okay, Judge. And the state wanted to make those efforts.
Oh, yeah, pick up the phone. That's what phones are for.
Yes, Judge. I mean, I'm good. I believe the state, wanted some time to make those efforts.
All right, it's 9:56 a.m. Somebody will call.
Okay, I'm not with the state judge, so, okay.
Oh
my
I'm
God.
to that.
All right, thank you.
Thank you.
I believe you're in.
Juan Orozco.
And down here on that, I don't believe he showed up.
Juan Orozco. All right, we're going to go on the record. Court is calling 2023 CR 0473 State of Texas versus Juan Emmanuel Orozco. Could I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
All good, Smith for the defense.
All right, this case was originally scheduled for February 13th, and the court allowed it to be recalled for today. It is now 9:57 a.m. This case was scheduled to be heard at 9 a.m. Defense, have you had any contact with your client?
No, Your Honor, I left a message on the number that I had and this morning about 6:30. Now, all I could do.
All right, and Deputy Laura, was there an announcement made, or could you make an announcement for Juan Emmanuel Orozco? All right, state.
Your Honor, state moves for bond forfeiture.
All right, that will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you.
You're welcome.
Sorry.
Joseph Garza. All right, Mr. Garza. Court is calling 2022 CR 10420, State of Texas versus Joseph Allen Garza. Could I have parties announced for the record for the state,
This on behalf of the state, Your Honor.
for the defense?
Ruben Flores for Mr. Garza.
And are you Mr. Garza?
Yes.
All right, you entered a plea of no contest on February 6, 2023. According to the plea bargaining agreement, punishment is to be assessed at 3 years in the prison, and there are no applications. All right, the court will follow your agreement, find you guilty, sentence you to 3 years in the prison, give you credit for any time served. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we're off the record. Mr. Garza, if there's a drug or alcohol problem, what I can do is I can request that you be placed in a therapeutic community. The therapeutic community does not increase your time at the prison. No? Okay. All right, good
I
luck
would
to
like
you.
to say something.
Sure.
I was trying to contact Mr. Flores. And I just told him about the time. And I just want to say, he threatened my life. And I would like to press charges up.
Mhm. All right, are you going into custody? Thank you.
Yeah, can you help me? Okay, next.
I understand.
I didn't even talk to him.
Yeah, you didn't threaten anybody's life. Okay, I understand.
I
Yeah.
understand. There's no way.
No. I've never known you to threaten anyone's life. All right, Norma, could you call the attorneys and let them know they need to be here? And Mr. Walbacher? You're Stephen Wayne Walbacher, correct? All right, the attorney who's going to be representing you is Mr. Robert Mauer. He'll be here shortly, okay?
Hire an attorney.
Why don't you have an attorney hired already?
I just found out that my attorney's.
Yeah. All right, just have a seat. We'll take care of that, okay? Yes. Thank you. All right, is there's anyone in here who's scheduled to be on jury? You need to wait outside. So are there any jurors in the courtroom? All right, court is calling 2019 CR 10914, State of Texas versus Maricela Beatriz Cuellar. Could our parties approach and announce for the record?
Daniel S. Clark for the state of Texas.
Eddie Garcia from Ms. Porter.
And are you Ms. Cuellar?
Yes.
All right, Ms. Cuellar, I'm going to show you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Maricela Beatriz Cuellar who was placed on deferred adjudication in 2019 CR 10914 for the offense of evading arrest detention with a vehicle on January 10th, 2020 for a term of 3 years? Is that you?
Yes.
All right, state.
Violated condition number 2 on or about 20th day of October 2020 in Bexar County, Texas. The defendant, Maricela Beatriz Cuellar, did then and there fail to submit to drug testing as directed by the court officer or supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Sure.
Your Honor, state waives all the violations.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine?
Speak up so she can hear you.
All right, so everybody to my right, y'all gonna need to be quiet and wait till the court is off the record. Sorry. All right, knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there an agreement?
Yes, Your Honor, it's to adjudicate guilt and then alternate for bi-weekly or includes bi-weekly UAs for 60 days on IVR call line and monthly UAs thereafter.
Is that the agreement?
It is, Your Honor.
All right, Ms. Cuellar, when you drug tested today, what are the results gonna be?
Negative.
Okay, we're gonna do a drug test today and then
You did one yesterday, Judge, at the direction of probation. I don't know. if the result
Probation?
of that,
are the results back for her drug test from yesterday?
I'm good right now. I'm clean.
All right, okay, let's do a drug test.
Okay.
Thank you. All right, so we'll do a drug test, then I'll make a ruling on this.
Okay, Judge, we'll stand by.
All right, thank you.
Thank you, Judge.
John Sanchez? Yes.
Thank you, Judge.
What's happening on this case?
Judge, we have, and I forget where we're supposed to stand.
No, you're in the right
Thank
place.
you, Judge. There's one motion I wanted to take up today. We have a motion for discovery and inspection that I've reviewed with the state, and they have some comments. I don't even know that I would call objections, and we'll just defer to the court on how you feel about it.
All right, I don't have the motion.
I'm sorry, I need to print it out and it's not in the file.
Yes.
I will take care of that. I thought I was ready and I'm not.
Okay,
Why
all
don't I
right,
do this
thank
to you,
you.
Judge? Sorry.
Just like-
Sure.
And there's.
Thank you. All right, can I have the parties approach on David Leon? Hello. So where are we on this case? Last time we were here, maybe some witnesses are supposed to be subpoenaed for March 7th. I don't know why we're here today.
Yeah, I filed a motion to allow my client, he's out on bond, Judge, but he's got a monitor. And I filed a motion to allow him to work, and when we were here last time, you said that he needed to get some kind of employment. And so I actually filed an amended motion with some information about Jose Pineda, who owns apparently a appliance repair place.
Okay, I think, and I could be wrong, but I think what I said was that if he wants to work, he needs to provide information. I didn't require him to get a job. He's on bond, so I have no jurisdiction over him being employed or not being employed per se. But I required that if he is saying that he wants employment, he needs to provide where he's going to be working and what the hours are.
All right, well, and that's what I was trying to give you, Judge.
Okay,
Okay, and so, so what happened is, this motion was scheduled for this morning.
okay.
That's
No,
why
no,
we're
no.
here.
So have you conferred with the state?
I talked to counsel.
Briefly, we spoke,
Yeah, so the name of this potential employer, now, please understand, Judge, that I have a local number for this employer. I've tried to call him and text him just to verify that my client can begin working. My client reports that he can start working immediately, doing appliance repair.
What are his hours?
He says 8 to 5, Judge.
All right, state, do you have any objection?
well, Judge, I mean, just one complication of this appointment, and then also the appliances are gonna be fixed inside somebody's house. This is burglary of a habitation. That's a concern of the state, because the facts of the case speak for themselves, and just the name of the case speaks for itself, burglary of the habitation. So that's a concern of the state.
We can go on the record, but I am going to have some issues if he's charged with burglary of habitation, which you are, Mr. Leon, and I don't take any of it as true. But if you're charged with burglary of habitation and now you want employment where you're actually going inside people's homes, I have an issue with that.
Judge, the alleged offense in this case was burglary of a habitation with intent to commit assault. This was my client claims he was going to say hello to a neighbor. And the complainants thought he was trying to break in at one of their Christmas parties. So there's really not any evidence of any intent to.
No, I understand, but he's going to have to, we can go on the record. Let's go on the record.
Okay.
Sure. Court is calling 2022 CR 9438, State of Texas versus David Leon. Can I have parties announced for the record for the state,
Jason Garahan, Your Honor.
for the defense?
Ed Cano.
And are you Mr. Leon?
Yes.
We have an interpreter here. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony? I'm sorry. Do you solemnly swear or affirm you will faithfully translate from Spanish into English and from English into Spanish? So help you God?
I do, Your Honor.
All right, you can lower your hand. So the defense has filed a motion to allow the defendant to work. State, do you have objections to that motion, and have you viewed that motion?
Yes, we viewed the motion. We are objecting to the motion. And if you want argument, I can give you more argument of the fact that I believe it's for an appliance repair. The state's opposed to it solely on the reason that, one, it's burglary of a habitation, what he's been charged with and alleged in his indictment. And the state believes that wouldn't be an appropriate employment in this case.
All right, so defense.
Judge Mike, just background information, there's a Jose E. Pineda who apparently owns an appliance delivery and repair location that my client reports he can commence working immediately between the hours of 8 and 5. The charge in this case is burglary with intent to commit assault. With the discovery we've had, it shows that my client never really gained entry into this premises. It was at a neighbor's place at his apartment. He claims he was trying to visit someone who lived at the apartment, and we maintained there was a misunderstanding, and whatever happened occurred outside the property, and there was nothing taken. There was no forced entry. There was no indication of any intention to commit any type of theft in the case, Judge. However, I understand we do have some pending charges here, Judge, but I just wanted to clarify some of the factual history that's been provided to me in discovery, Judge.
All right, thank you, counsel. Here's the court's concern. My concern is that he's charged with burglary of a habitation. And now I have a request for employment that requires him to go in homes. Now, Mr. Leon, I don't take any of this as true, the fact that you actually committed a burglary of a habitation, because I don't have any information for that. But I do have an issue with allowing you to go into people's homes when you're charged with burglary of a habitation. So this employment, if this employment is, he's just going to help repair and clean appliances, then he can do that. But if part of his employment is for him to actually take repaired appliances into people's homes, the court is not going to allow him to do that. So is that what's happening here? It's fine.
I'm not clear. I did try to contact Mr. Pineda, left him a text message in the phone, so with all due respect, Judge, I cannot represent an officer of the court that what actually is going to happen, but my client obviously needs to know is that if this employment requires him to stay at his place of employment and not visit locations in the community for deliveries or repair, then he just can't do it, or he's got to find something different.
All right, so I'm open to your client having employment, but I'm not open to your client having this charge and going into people's homes. So if, with regards to this place of employment, if the employer can provide in a letter that his only job will be cleaning appliances or repairing appliances and not going into people's homes, then the court will strongly consider allowing him to have this employment. Otherwise, he needs to seek some employment doesn't require him to go into people's homes.
We will see what we can get, Judge, and supplement our motion accordingly.
Okay, all right, thank you. Mr. Leon, I hope you understand the reason why I'm saying that you can't have employment where you go into people's homes. Thank you. All right. Donata.
Yes.
Thank you.
All right, thank
Can I
you.
be excused?
Yes,
Excuse me.
yes, thank you so much for coming in. Christopher Cantu. Who's the attorney for Christopher Cantu?
He's in custody.
All right, Mr. Cantu, come over. All right, where are we on this case?
The state has subpoenaed records they're not in possession of. I believe we're still in need of discovery.
All right, what discovery is not available yet?
CPS records, Your Honor, that were requested back in January. We're just waiting on those to return.
All right, has anyone had contact with CPS broker or the attorney for CPS to see when the records will be?
I was unaware.
It's unclear, Judge, from my notes. I know they are a little bit backed up. They were requested back January 17th, if I'm not mistaken. But we can follow up with CPS and see if we can get a rush on those.
All right, Ms. Ferguson. Can I have this set for the beginning of April? All right, so Mr. Cantu, I'm making sure that your attorney has all of the discovery. So we're going to come back April 3rd with the CPS records and hopefully they'll be in. Is there any other discovery other than the CPS records?
Not that I'm aware of, Judge. But as you know, I'm not in control of the state files.
Okay. All right, so we'll see you back on April 3rd. Is there anything else, Mr. Cantu?
No.
All right, thank you.
Which way you want him to go? Back to the.
Andrew Pena?
Yes, sir.
Yes. This is off docket?
Yes, ma'am.
Yes.
And who? Ms. Cuellar was the-
Okay, awesome. Yes.
Yes, ma'am. If the court remember, Mr. Pena is the gentleman who is in drug court, bounced
Yes.
out. We reset him. He went to the VA. They released him from the VA and told him to go, he's going to a rehab in Austin.
Yeah, no, he needs to be here. He's not going to rehab in Austin.
Okay, well, that's where he is now.
He needs to get back from Austin because he's set on Monday.
Okay,
All right, thank you.
yes, ma'am.
All right, I appreciate you.
Sure, I just.
All right, thank you. Demetric Jackson?
He's downstairs, Your Honor.
Okay. John Sanchez? Yes.
Number 8. Yes.
All right, before we, I guess it's a motion for discovery. You have this as number 5. Is this the 5th motion for discovery or is just labeled 5?
It's labeled 5, Your Honor. It's the 5th of, I believe we filed 9 pretrial motions, and just for reference in our system is number 5, but it is not the 5th motion for discovery.
Okay. All right, State, are you ready to proceed on this motion?
Yeah, no, I'm ready.
All right, court is calling CM 099192, State of Texas versus John Albert Sanchez. Could I have parties announced for the record for the state,
Brittany Mitchell for the state.
for the defense?
Jason Todd for the defense, Your Honor.
And are you Mr. Sanchez?
Yes, ma'am.
All right, the court is in receipt of motion labeled 5, motion for discovery and inspection. State, have you had a chance to review the motion?
I have, Your Honor.
All right, any of these items agreed upon?
There are some that are agreed upon. I'll say, number 2 is simply not applicable. There was no testimony in grand jury. We'll agree.
All right, well, let's just go through one at a time.
Okay,
All right, number 1, is that agreed to?
Your Honor, I would ask for an amendment of the language to reflect the requirements in 3914. This is a little broad. It says which might in any manner be material. I ask that language reflect that might be exculpatory or mitigating or used for impeachment.
Your Honor, under Watkins v. State, material is the standard. And so I believe we look at 3914. 3914 delineates what needs to be turned over. The standard for that is what's material to the case. All we're asking for is something that, and in Watkins is defined as some logical connection to a consequential fact.
Oh, well, what I'll do is I'll grant the motion. I mean, I'll grant number 1, but with the caveat that it must follow the rules of 3914.
That's fair. Thank you, Judge.
Sure.
Understand.
All right, number 2.
It's not applicable. There was no testimony in grand jury.
So there's no grand jury testimony. Do you wish to still have number 2 or you want to withdraw number 2?
I would, I guess we're relying on the state, and if there is none, I don't see a harm in having it granted, Your Honor, because the only way we would know is if you tell them to turn it over.
All right, so what number 2 states, state is, it says if applicable. So obviously, it's probably not applicable. You're telling me it's not applicable. So I'll grant it.
Okay.
Number 3.
Numbers 3 and 4 would we agree.
Okay. Number 5.
Number 5, again, it's not applicable, but we'll agree to abide by it.
All right, thank you. Number 6.
Number 6 will agree.
7.
And number 7, Your Honor, it's really just an issue with it being a little too broad. I would just ask for the language rely on to be taken out. My concern is later on, if we have expert witnesses, they may know of some study that their knowledge is relying on, and we're not going to be able to necessarily give that exact study when it comes up in testimony, Your Honor. So I would just ask for rely on to be taken out. If we're introducing it or we're referring to it in the testimony, we will provide a copy.
Your Honor, I think if this is specific to an expert, that we would have an expert hearing. to parse that out and would come in front of the state. I just would ask the state to keep the language. We're unable to cross-examine, we're unable to properly confront if we can't confront what an expert is relying on, what any witness is relying on. We're
But
not
how would-
asking for all information they've had over all time.
How would they know
How
if
would
an
this,
expert is relying on some published material? Because it's the expert who, I'm assuming, will testify. And then people will get a chance to cross-examine them and say, what treatise did you rely on? What publication are you relying on? Excuse me, do not come into court making announcements. You need to come in and be quiet. If you're going to come in and make announcements, we're going to have you excused. Are you a juror?
I don't know, I'm a client, I'm here for court,
All right, could somebody see who she is?
Joanne Muniz. Okay, thank you. They say no. My brother can-
Yes, and if, and Deputy Laura, she's not set today. Let's see if we can find her attorney for an evaluation. All right, so we're back on the record.
Thank you.
You're welcome.
If you never-
All right, thank you. It's Tuesday. All right. All right, so what I was saying is with regards to them, their expert relying on some publication, unless the state specifically asks them when they're interviewing them, what books are you relying on or what treatise are you relying on? They would know to turn that over if they haven't asked the question.
and I don't think it would be unfair to not ask them to ask that question. What are you relying on? I think is essential. And if we're going to cross-examine an expert,
Well, I mean, that's what you cross-examine. You ask the expert, what books are you relying on? And then they will give it to you. And I'm assuming that defense, although I know you're not under any obligation, would perhaps speak to the expert beforehand and say, what are you relying on to come to your conclusion? Do I think maybe the state should ask an expert during preparing them for testimony, what they are relying on to come to their conclusion? Yes, but I'm not the prosecutor. So as far as the rely on, I don't know how they can give you information about what an expert is relying on.
Your Honor, I guess I would just rehash, all I have to do is ask. I understand your I understand your response to that. And my only response would be, is it, when we confront an expert or when we cross-examine an expert, it's essential we know what they're relying on, so that someone doesn't take the stand and puts out theories that the court doesn't know about or that we don't know about, that we can't challenge if appropriate.
But isn't that when you request to have a hearing?
And I'm fine with that.
Yeah,
If
okay.
that's when it happens. I think if it comes to light that an expert or a witness is relying on something, then we should get it. That's what we're asking
Oh,
for.
I mean, well, then you request your hearing. And the court is always available for you to have hearings. Then you request a hearing with that expert. And if you all want to request a hearing with the expert before trial, the court is more than welcome to hear that. I don't know, there's something loud happening in the hallway. Is this a part of the training? Okay. All right. So I'm going to take out the word rely, but defense, what I will tell you is if you want a hearing with regards to whatever expert they have, I will give you a hearing before jury trial. So it won't be during trial. We have a hearing, just requested and the court will make that happen.
I appreciate that, Your Honor. I think this also raises, though, in the situation that I'm thinking of more specifically, because I know that you will grant us that hearing and we'll work it out. We've had situations where the government elicits a question of, why would this be wrong? And someone would say something to the effect of, well, it's against the human resources policies.
Mhm.
If the state's eliciting that testimony, then they knew that someone was going to say this is against the human resources policies. That would be something they're relying on. It's also something they're referring to. It's also something that's coming up in testimony. We believe they should provide that to us. So the expert hearing is fine, but it's just, there's other situations where all we can rely on is the state asking the question. We don't get an opportunity until they're on the stand.
Okay. All right, court has made its ruling. Is there anything else with regards to discovery?
Your Honor, just, the state would ask, there's a provision at the bottom. Asking, or it says that the defendant and the defendant's attorney.
What page are you on?
I guess it's the third page, the top of the third page. It's talking about the notice. I would just
Let me
ask,
see your page.
yeah. So there's the enumerated
Yes.
section, and then when it starts the narrative.
All right, so I'm on that page now.
Okay. So at the top where it says, it's asking for 10 days notice if there's any additions to this, I would just ask that it's a reasonable notice, which mirrors what's in the code. Obviously, we're talking about because we don't know what issues will come up. I mean, I imagine 10 days is sufficient, but I don't want to.
Well, I mean, what it says is within 10 days, if prior to any trial or hearing, and as soon as they become aware of such information. So if you become aware of the information on day 20, I'm sorry, on day 5, then that's when you became aware of it.
Okay.
All right, is there anything else?
That's it, Your Honor. Thank you, Judge.
Sure, okay, is there any other than what we've gone over here, is there any other outstanding discovery?
There is, Your Honor.
Yes, what's outstanding?
The state has a phone that they've done a search of that we have not received yet.
Okay.
There's mention of DNA that I don't believe, it's not clear to me what the results of that are, or and we haven't received any results of that.
Okay.
There was a CPF report in this case that we have not received from the state yet.
Okay.
At the very least, that's, I know those things are missing. I have not had the opportunity to look at the forensic interview yet, and we're doing that this week.
All right,
We're trying to schedule that this week. Your Honor.
all right. So with regards to the CPS records, the court, of course, will sign a release for that. Ms. Ferguson. I need a 45-day reset on Sanchez and state with regards to the phone, is this an extraction or something else?
I believe it's an extraction, Your Honor. It's a brand new indictment. I think it was indicted about 2 weeks ago. So I haven't had a chance to really delve in.
So I normally don't do this, but I'll give you a 45-day reset if you all can confer on off docket. And then when we're back here in 45 days, if there's any other outstanding discovery, let me know and we'll see where we are on it.
Thank you, Judge.
You're welcome. I'm sorry. All right, we're going to come back on April 6th. Ms. Ferguson will give you a reset form after you receive that. You are excused.
Thank you, Judge.
Thank you. Always
It's
good to see you. Yes.
Real briefly, Your Honor,
Yes.
Just a point of clarification
Yes.
on Mr. Pena, who said he set for Monday. I think he set for the 27th, just.
What date is Andrew Pena set for? All right, yes, he needs to be
And
here.
Monday with holiday, so I knew.
Okay, sure. No
Okay,
problem.
thank you.
You're welcome.
All right. Your Honor, may I approach briefly?
Yes.
Your Honor, Mr. Bolden,
Mhm.
security needs you to give me an order to allow me to bring the clothing upstairs. You know what, on the motion I thought there is an order, if you just want to handwrite that I can transport that clothing upstairs.
Sure, we're just waiting for him to get here.
Okay, so I'll check in with my other courts and I'll come back and check.
All right, thank you.
Thank you, Judge.
You're welcome. Who's here on Cuellar? Maricela Cuellar? Thank you. We're back on the record on 2019 CR 10914, State of Texas versus Maricela Cuellar. All right, Ms. Cuellar, I have received the results back. And I'm so happy that you were negative. I'm glad that you're doing what you need to do, okay? So let me ask you, is there a reason why you haven't been submitting? What's going on in your life?
It was just a lot, and I know I don't want to explain it, and it sounds like an excuse.
No. I just want to find out so we won't be here again.
Well, back when I first got put on probation, that's kind of like when COVID started and my mom did get sick.
Mhm.
So I was working 2 jobs at the time. I was working at Santa Rosa and I was working at Wendy's.
Okay.
So I was just constantly on the go. And I wasn't really thinking so much of myself. I was just, you know, trying to make ends meet for my mom and my stepdad, because I was helping my stepdad at the time pay the rent. I was paying my mom's car. And I just got off track, I guess you could say. And now that I have my son, I realized the opportunity that I had, which was deferred probation, was a big opportunity that I could have, if I would have just submitted my drug test, that, you know, it would have been a good thing for me. But now I'm just trying to do better for my kid, for my family. I'm taking this as a life lesson.
Okay. So are you employed now?
Yes, I am. I
And
work
what do you
at
do?
Chick-fil-A, Alamo Ranch.
Chick-fil-A, they do put sugar in their recipe, don't they?
Honestly, I have no idea.
All right, so they've told her not to ask. I think they put sugar in there or something, you know?
Judge, it's an ironclad NDA.
Yes,
It's hot sugar.
but you know, if you go online, they will tell you what exactly they do. So I'm partial to their lemonade, but that's just me. All right, what are your hours working there?
For now, I'm doing like 5 to close, which is like 5 to 10 or 11 the latest.
Oh, so 5 PM to close.
Yes.
All
I
right,
was supposed to be alternating with my mom, because my mom works in the mornings there. We work at the same location. And she was supposed to be my childcare,
Mhm.
but she broke her foot. So now it's me and my boyfriend that are alternating schedules. So he'll work Monday through Wednesday and I'll work Thursday through Saturday.
all right. And so how old is your child?
It's 7 months today.
Oh, okay. So you trust your boyfriend with your baby?
Oh, yes, he's a great father. He's
He's the biological father?
he's
Okay.
he's a great father. He helps me a lot. When I was in custody, he was amazing. He would go to my mom's every day, you know, have my mom see the baby. He took care of the baby. So he didn't really have help.
Boy or girl?
He's a boy.
All right, what's his name?
Kenji.
Okay, Kenji. All right, that's a great name. That's a cool name. And court reporter wants to know how to spell that.
Kenji.
Okay. All right, so this is what the court is going to do. Court is going to deny the motion, alter the main conditions to include probation. Should we do UA hotline for her? Or what do you want to do? I'm not going to find her guilty.
Well, Your Honor, her case expired January 9th, 2023.
Ah, so she's done. Yeah, I'm denying the motion. You're done.
Happy birthday to your son.
Yes. All right, read off the record. So here's the thing. You've done great. You're on the path. You've been testing negative. You need to make sure you do that because your son is depending on you.
Oh, yes. He's like everything.
Okay. All right. Good luck. Happy Valentine's Day.
Thank you so much.
All right. Bye-bye. All right. Are we ready on well voucher? Well, before you come up, your attorney, he's not here. Just 1 second. Yes.
He doesn't have an attorney.
Mhm.
It's time to hire an attorney. I've agreed to represent him today. I've agreed he would like to reset for a week or two.
Well, I mean, are you being hired?
He says he's gonna hire me. So I can't do it right now. Tomorrow I need to meet with him. Yes, I believe I'm gonna be hired. Am I gonna be hired? We've agreed. I need a little time. I need to get to discuss it. So a week or 2 weeks is what we're at.
All right, Ms. Ferguson, we're going to recall Mr. Wahlberger for next week. All right, so we'll be back on February 23rd. Ms. Ferguson will give you a reset form. Who's here on Demetric Jackson? Come forward. Is there any jurors in the courtroom? If there is, you need to wait outside. Yes, oh, come forward. All righty, what is happening with Mr. Jackson?
Good morning.
Good morning. We
Judge,
had it recalled back because he had picked up a new case. That's why he's in custody.
Correct, Your Honor.
All right, so what's happening?
Judge, I spoke.
Well, I haven't had a chance to look at the new
All right,
case.
y'all want to confer? All right, have a seat. Yes.
Samantha Richards is pending on the 2 armed robbery charges. The prosecutor is still reviewing those with a possibility of dismissal.
All right, Samantha Richards, come forward.
My client has been called by her son's school that she needs to go pick him up.
All right, okay, and you're right there, Mr. Young.
And
And she's right there.
prosecutor, she has no objection. to a
Okay,
short-
all right, John, you're right there and she's in the middle. All right, who's the prosecutor on Samantha Richards?
I'm here, Your Honor.
All right, we're set for jury trial on this today.
We are.
Yes. So what's happening with the jury trial today?
Your Honor, we
Because I mean, this was sent to impact. I'm showing here that this was set to impact on October 31st. And then it was reset for December 5th for jury trial and plea deadline date. And then on December 5th, it didn't go to jury trial. So now it's set today for jury trial.
All true statements, Your Honor.
I'm sorry, what?
All true statements.
Okay, so what's happening with this case? Because it's set for jury trial. Y'all need to discuss that.
We have, Your Honor.
Well, I mean, she's up for jury trial.
I'm always reviewing the case. It doesn't, I have, at this point, Donna, you have the victim, but
All right, so,
there are considerations in this case.
all right. So she's set for jury trial today, so something needs to happen today.
Very well, Your Honor. What I was going to ask is if we could have a short reset because my client has to pick up her son from school. They
I'm
called her and said that she needs to go pick her son up.
Yes. Okay, I can't hear anything. Everybody's mumbling.
I can have my sister go get her.
Let's speak up.
I can say that I could have a family member go pick him up if necessary.
All right, so let's have a family member do that. All right, thank you.
Thank you, Your Honor.
Court is calling 2023 CR 0881, State of Texas versus Amanda Villegas. Can I have parties announced for the record for the state?
Jason Garrett for the state, Your Honor.
Who's the attorney for Amanda Villegas?
Josie Richardson for the defendant, Your Honor.
Judge, actually, we have a substitute counsel for state.
All right, thanks for the state.
Debbie Cruz on behalf of the state, Your Honor.
And are you Miss Villegas? Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Villegas, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Ms. Villegas, I'm showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of driving while intoxicated with the child under 15? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
That's true, Judge.
Ms. Villegas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishments be assessed at 2 years in the state jail facility. There's a $1,500 fine. State recommends community supervision, the VIP, and ignition interlock. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, sir.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have, I'm sorry, did you understand by, I'm seeing something else that's popping on my screen. Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation of 150 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
The state introduced State Exhibit 1 and all of its attachments.
No objection, Your Honor, but you did want to plead no contest.
All right, are you pleading guilty or no contest? I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront the state calling the right to remain silent? To understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand? Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept the evidence, states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. We respectfully request that the entire fine be probated.
All right. Ms. Villegas, is Child Protective Services involved?
They have another involved.
So where's your child?
She's with me. She's with me.
All right, so you want to explain to the court why you were driving with an infant asleep in a baby seat. And according to this, you had 2 open containers and a center console cup holder, a 24-ounce Bud Light, 24-ounce of twisted tea, and that your speech was slurred and they had odor intoxicants coming from your breath and your eyes are red and glossy. Where are you coming from?
From my family's house, 3 down the street from my house, trying to get home.
All right, you're gonna have to speak up. Where were you coming from?
Family's house. We were drinking at family's house.
So your family allowed you to leave after you had been drinking with an infant in a car seat. Nobody said, hey, you're intoxicated. You should not be driving with an infant in a car seat. Okay, you're whispering.
No, nobody.
So how have you been addressing your alcohol issues?
I don't believe about alcohol issues.
Again, my statistics professor would be very upset with me, but usually people who get pulled over and plea to driving while intoxicated, that's just the first time they got caught driving while intoxicated. I don't know anybody who is taking an infant and driving with an infant while you're intoxicated and saying, I don't have a problem. Obviously you do. And obviously your family has a problem if they were so intoxicated that nobody told you you should not be driving, one, at all, and doubly when you have an infant in the vehicle. So when's the last time you had alcohol? And you need to be honest with the court.
I haven't been drinking since then.
All right, everyone needs to whisper. So when's the last time that you drank alcohol?
Since I got caught with alcohol.
All right, I find that unbelievable. Are you in any type of program? All right. Do you have any criminal history other than this?
Misdemeanors.
Misdemeanors for what?
When I was like 17.
No. What's the charge?
Possession of marijuana and failure to ID.
All right. And if you're drug tested today, what are the results going to be? All right, let's do a UA. And we'll come back and take care of the rest of the hearing after she submits her UA.
Okay, how long should that be?
Oh, it'll be fairly quick.
I'll just make a short exit for 5 minutes. Will it be okay?
Yes, 5 minutes, but we have a jury coming in at 11:30, so you need to be back before 11:15.
Thank you, Judge. Happy Valentine's Day.
Oh, happy Valentine's Day.
I got an important flower run after I leave here.
Okay.
And dark chocolate run.
Okay. See, I did the internal thing. And are they waiting on this again? Richards? Are they waiting on this again? That's John, yeah. Okay. Yes. Okay. Oh, hello. I don't know.
Tuesday number. For your staff, you got other kids that had like.
All right, who's here on Gloria Rosca? Where's the attorney on Gloria Rosta? Excuse me, where's the attorney on Gloria Rosta? Who's the attorney? All right, Miss Orozco, come forward. Is he in a commitment docket tomorrow? No. All right, Miss Orozco, we're going to bring you back on February 15th. Miss Ferguson will give you a reset form. Your attorney is at another docket call. All right, thank you. They'll give you a reset form and then you're excused. Okay, awesome. All right, court is going back on record in 2023 CR 0881, State of Texas versus Amanda Villegas. All right, Mr. Richardson, I need you over there. All right, this is what the court is going to do. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 2 years. There's a $1,500 fine that will be probated. There's to be the VIP, ignition interlock, DWI education course, 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to want parenting classes. Once those completed, the remaining of the community service hours will be waived. There's to be ignition interlock for a full term. Counsel, the court will reconsider once she has been on probation for a significant amount of time. I'm going to want 90 meetings in 90 days. Probation, do a TAP evaluation. If the TAP evaluation recommends inpatient treatment, we're going to start with supportive outpatient treatment. I'm going to want field visits 1 time per month, and probation, that field visit can count as her reporting. There's to be regular reporting by Zoom or in person. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors? All right, probation, is there anything else?
Continuances.
Thank you. And regular UAs. Anything else, probation?
No, Your Honor.
Ms. Villegas, is there anything else you need from the court? Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. We can go off the record. Here's the thing, Ms. Villegas, whenever you get behind the wheel and you've been drinking, what usually ends up happening, if there's an accident, the person who's driving intoxicated, it's rare that they get injured. Usually it's somebody else gets killed or somebody else gets injured. In this case, it could have been somebody else or it could have been your child. If you love your child, then you should not be driving after having taken a drink. And while you're on probation, you're not allowed to drink alcohol at all. That means if you go over to your family's house and you all are having a barbecue or whatever, you're not allowed to drink alcohol on probation, period. You understand? All right, good luck to you. Probation will go over conditions.
Judge, on the interlock, after about a year, do I talk to you in person or?
Yes.
Okay, thank you.
You're welcome. All right, court is calling 2017 CR 7713W, State of Texas versus Raymond Gutierrez Jr. All right, if we have parties approaching, announce for the record for the state.
Daniel Escobar, State of Texas.
Defense. And are you Mr. Gutierrez?
Ma'am.
Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Raymond Gutierrez who was placed on community supervision in 2017 CR 7713W for the offense of possession of a controlled substance? Penalty group 1, 4 grams to 200 grams on July 10th, 2018 for a term of 5 years. Is that you?
ma'am.
State?
Violated condition number 5 in Bexar County, Texas. The defendant Raymond Gutierrez Jr. did then and there fail to report to the supervision officer as directed for the months of August, September, and October 2022 in violation of condition number 5.
How you plead to that? True or not true?
Your Honor, state waives all the violations.
Any objection?
No, Your Honor.
All right, did you understand by pleading true to number 5, the court could find it true, grant the motion, and sentence you up to 4 years in prison? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is that an agreement?
Yes, Your Honor, there is an agreement for 4 years TBC.
All right, is that your agreement? Are you asking the court to follow that agreement? All right, you're mumbling.
Yes, ma'am.
Are you waiving your right to appeal? I'm sorry.
Yes.
All right, the court will follow your agreement, grant the motion, sentence you to 4 years in the prison. There's $1,000 fine, time and money will run concurrent. And give you credit for any time served.
Judge, in connection with that, he's got 308 days in jail. He completed successfully, ISF for 133 days at Applewhite. And then an additional 90 days at the Henderson unit. So we'd ask that you give him credit for a total of 531 days.
All right, the time at the Henderson unit, was that successfully completed?
Yes, both of them are.
All right, the court will give you credit for any time served and credit for any time served in inpatient. All right, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. We can go off the record. I don't know why you wouldn't abide by conditions, but you're gonna have to do better with your life.
Yes, ma'am.
Otherwise, you're gonna end up in and out of prison. and you may end up using drugs, and in which case you never know what you're gonna get because it's not FDA approved. And that may be the last time you use drugs. You understand? All right, good luck to you. You're welcome.
Good luck.
Who's here? Why do I have Amanda Villegas back?
Oh, no problem.
Oh, yeah, it's because it's Valentine's Day. We're just gonna blame it on Valentine's Day. Yes.
Excuse me. That was from yesterday when you said you wanted me to bring it in person.
Yes. No. Kathy.
Yes. Thank you, Jeff.
Demetric Jackson. Hello. So what's happening with this case?
Well, Judge, they've made an offer, but again, I haven't looked at the discovery. Apparently there's some discovery also missing.
All right, so there's discovery that's missing. What discovery? And this is the discovery with the family violence case?
Correct.
All right, what discovery is missing?
Yeah, we're missing EMS records that were previously subpoenaed, however, there's an error with this, and so those were re-requested.
All right, so when will you have them?
We should have them soon, Judge. We just have to follow up. Typically, those take about 3 to 4 weeks, but it's been a while.
All right, Ms. Ferguson. On Jackson, I need a 30-day reset. Mr. Jackson, if they have those records before then, or if your attorney wants to come back before then he can always request it. All right, what date?
Judge, I can do.
All right, so we'll come back on March 27th. All right, you all are excused.
Okay.
You're welcome.
Thank you.
You're welcome. If there are any jurors in the courtroom, you need to wait out in the hallway. All right, who's here on Jose Garcia? All right, court is calling 2022 CR 2009, State of Texas versus Jose Guadalupe Garcia. Could I have parties announced for the record for the state?
Jason, do you have from the state, Your Honor?
For the
Matt
defense?
Stolmansky for Mr. Garcia.
Are you Jose Garcia?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor, I have.
Court will find that the state is in compliance with discovery. Mr. Garcia, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
And for all parties, are we proceeding on this case only? Are we proceeding on this case only?
Oh, yes, ma'am. The others will be encompassed in the plea.
All right, thank you. Mr. Garcia, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with felon in possession of a firearm? Off the record for a moment. Mr. Brooks, are you enabled? If you can move down, you and your client move down that way. Thank you. No problem. All right, did you understand you're charged with felon in possession of a firearm? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today did you understand that today by entering in this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court would grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain agreement. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is be assessed at a cap of 8 years in the prison. There's a $1,500 fine. The state is remaining silent on your application. They're taking in consideration 2023 CR 0705, 0706, 2022 CR 3151, and County Court Cause number 688228. There's to be restitution, if any, to Hector Calderon in 2023 CR 0705. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, ma'am.
State?
It is, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Okay, no contest, ma'am.
State any evidence?
Yes, Your Honor. State exhibit number 1 with all of its attachments.
Your Honor, I've reviewed those with my client. We have no objection.
All right, Mr. Garcia, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied up for deferred adjudication. We will come back on April 6th. At that time, I'll make a decision on your application. My decision will be based upon any information I received and any other evidence that's presented. Is there a need for a TAP evaluation or no?
No, ma'am.
All right, so probation, just PSI report, no TAP.
Your Honor, Mr. Garcia is in custody. We were here on the 24th or 27th. I don't remember which day it was. We broke for lunch. He left. His wife went into labor. They had a little baby girl. I got in touch with his mother, told him that if he didn't come back, he'd have a warrant. Well, he didn't get back. So the next day or 2 days later, he turned himself into the police for this warrant. We're asking that you reinstate his bond. As far as excuses go, it's a pretty good one.
All right, so I'll need some actual documentation.
Baby.
Well, no, I mean, not the baby, but some documentation about, the fact that she was at the hospital that day.
Yes, ma'am. Well,
Right.
she was here. And then she went into labor here and then they went over to the hospital and she had.
All right, so if you'll bring documentation
something,
of
yes,
that
ma'am.
and share it with the state, and then I'll
Okay.
consider it.
Thank you.
All right, thank you.
We have a number.
Who's here on Martin Martinez? Where's the defense attorney on Martin Martinez? Oh, I'm sorry, Miss.
No, Mr. Bloomquist was in here not long ago.
All righty, just have a seat.
Thank you.
All right, it's 11:15. Yeah. All right, everyone. So I informed everyone that people were going to be sent back at 11:15 because we're starting up a jury trial. So, where are we? Hi. Okay. All right, so which client are you doing plea paperwork on?
They're working on the paperwork on Amy's, Your Honor, and then on Salceda, I said it was the second setting. I don't know if we need to do discovery acknowledgement.
All right, so everybody is rushing forward. You're rushing forward too late. So you're gonna have to come back tomorrow. We'll get the plea paperwork for your guy today. So if you can hold on to her person, everybody else, you need to come back tomorrow.
Jonathan Bolden's one.
Hmm?
Jonathan Bolden.
Just give us a moment.
Very well. Good, you just called me, but I was out. I'm ready. Martin.
All right, Martin Martinez.
Apologize. Okay, I'm ready to speak up. So she's here.
Yes.
My client, Judge, it's Mr. Christopher Garza. We already did a plea adjudication and accepted that. It was an agreed recommendation and deferred. I don't believe that we need a PSI or that. I wanted to bring that to your attention to see if
Okay,
you would reconsider that request so we can get in agreement.
all right, so we're bringing a jury in at 11:30, so they'll have to come back tomorrow.
Okay, so we'll just bring it back tomorrow, Judge?
Yeah.
That'll be fine.
Okay. All right, court is calling 2022 CR 8754, State of Texas versus Martin Daniel Martinez. Could I have parties announced for the record for the state?
Deputy Cruz, on behalf of the state, Your Honor.
Attorney Bloomquist, Larry Bloomquist for the defense.
And are you Mr. Martinez? Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Caroline. Mr. Martinez, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Counsel, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? And counsel, did you review it with your client?
Yes,
All right. State, I'm sorry, defense, do you waive the reading of the indictment?
we do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Martinez, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with deadly conduct firearm as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine.
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, sir.
All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at a cap of 5 years. State is remaining silent, and they're taking in consideration 687,552. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, sir.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney?
Yes,
Did
Your
you
Honor.
understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense is charged. How do you plead? Guilty, not guilty, or no contest?
Yes, Your Honor.
State any evidence?
At this time, the state introduces state's exhibit number 1 and all of its attachments.
No objection.
Mr. Martinez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there was no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. This will come back on April 6th. I'll base my decision on your application based upon the PSI report and any other evidence that's presented. Probation, I need a PSI and tap on Martin Martinez.
Will you be excused, Your Honor?
He needs to speak with probation.
I'm gonna have him sit.
All right, thank you.
See that?
So Ms. Ferguson, Adame Manuel, tomorrow, the 15th. What is happening with Brendan Guzman?
Judge, I am extremely ready. I have been ready for the last 3.5
Okay.
years.
All
I filed a writ and a speedy trial motion. I'm ready for trial. I'll waive a jury. You can send me to any court that'll take my case.
Oh, you're waiving jury?
Oh, sure. I'll try the case to you right now.
All right, you want to talk to the state about
Sure.
bench trial? All right, Travis Murray, that's coming back on the 15th. Jonathan Boyd, 15th. Neely is coming back this afternoon. Mark Salcedo. That's coming back on the 15th. Juan Ratana. Where's Juan Ratana? Is he dressed for trial?
This is downstairs.
Yes. All right, so defense attorneys, do not stand in front of me because if I'm saying you're coming back on the 15th, you're coming back on the 15th. Cruz Rivas. I think that's been completed. Brianna Gutierrez did not show.
Oh, she's here, Judge, and we have
She's late.
a motion to this.
I just, I found a motion. Okay.
Yes.
Just keep left over, don't go anywhere.
Thank you.
Judge, I conferred with the state and they did not agree with my jury waiver.
Okay.
So Norma says I'm coming back in the morning.
Yes.
Okay.
Manuel Dame, the 15th. Wilbert Villamil, the 15th, be back tomorrow. All right, so who's who? That's tomorrow.
Tomorrow?
Mhm. Well, no. Your client's dressed for jury trial. So he's, yes,
Okay.
all right.
What time?
Oh, we're starting with jury selection at 11:30.
15 minutes.
Mhm.
My.
All right, state. Yes. What case is it so I can pull it? Oh, yes, Samantha Richards is the same.
Ready? I mean, we can be ready now.
Ready.
Okay. All right, so let me see the files that are up for trial, please. And where's Christopher Garza with Raymond Bell? Yes. All right, and then Juan Avalos, where's Luis Martinez? All right, could somebody call Mr. Martinez? And Abelarda Torres.
I'm here. I'm sorry, I didn't hear what you said.
Yes, what is happening with Mr. Abelarda Torres?
I have not talked to the judge. I was substituted for him for December.
Okay.
I do have an offer that I got from Mr. Garrett last week.
Okay. And where is Bill Davidson on Raymond Ruiz? All right, Raymond Ruiz, can you hold on to him, please? Is that something for me?
What's that?
Is that something for me?
It will be for you in a second. It's part of it.
Okay, all right, thanks. Yeah.
Yes. I do. Yes.
All right, so did you get in touch with Luis Martinez? All right, I don't know what people don't understand about jury trial settings. Okay, thank you. Who's here on Aaron Trevino?
We're present, Judge.
All right, where's your client?
Custody.
All right. Deputy Laura, when you get a chance, can you bring out Mr. Trevino? All right, thank you. Deputy Laura? Deputy Laura, release the jury. Tell them to be back here at 1:15. Yes. All right, no, I understand.
Better Valentine's Day, Judge.
It's going well.
After the sun. Yeah, he didn't. I got stuck in children's court this morning. I'm sorry. All my clients are on run, you know.
Yeah.
Or in SEMO.
They'll come back.
You don't miss that.
No, they'll come back on the day of trial.
That's what happened. I thought it was gonna be a quick setting because the kid's on the run and she showed up on the Zoom. So, yeah.
Say the word, I'll be back. Really.
Juan Carlos Ratana with a miscellaneous motion. All right, who's the attorney on Juan Carlos Ratana? Is that? All right. Who's here on Maria Neely? All right, thank you. And could somebody call Celia Cavazos? I think she's the attorney for Brandon Sierra. All right, so Mr. Sierra, if you'll come take a seat in the box for me, please. And can I see that violation report? All right, Mr. Sierra, you're going to be taken into custody today. Based upon your charges, you're making unauthorized stops. I'm going to remand you without bond. If your attorney wants to have a hearing, what will end up happening is your attorney can request a hearing and the court may reconsider. But for now, you're going to be taken into custody. This case has been set for 2 different days. So that's where we are, okay? Ms. Ferguson, if you let his attorney know. Sorry. All right, court is calling 2022 CR 10260, State of Texas versus Maria Antoinette Neely. We're going to have parties announced for the record for the state.
Jason Garrett, Your Honor.
Defense.
Meredith Chacon for Miss Neely, Your Honor.
And are you Miss Neely?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor, and I have signed the discovery acknowledgement. And before we begin the plea, I just need to put one short thing on the record with my client. If that's
All right, so the court will find that the state is in compliance with discovery and you may put on the record what you wish.
Miss Neely, you had originally filed a motion to have a different attorney appointed back in November. Are you asking the court to disregard that and have me continue as your attorney today? And are you satisfied with my representation? Yes.
Oh, thank you. All right, Miss Neely, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Ms. Neely, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
And did you understand what you're charged with is manslaughter as a 2nd-degree felony? The range of punishment is anywhere from 2 to 20 years in prison with a possible fine up to $10,000.
Yes, ma'am.
And the repeater, Your Honor, we're proceeding with that.
All right.
Okay.
And so with the repeater, if it's proven, then that makes it a 1st-degree felony. The range of punishment for that is anywhere from 5 to 99 years or life with a possible fine up to $10,000. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and rights to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Neely, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargaining agreement, you agree that you've been previously convicted of a felony for purposes of enhancement. Punishments be assessed at 8 years in the prison. There are no applications, and the state will take in consideration 2022 CR 10259. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
It is your honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it, and did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, state exhibit number 1 with all of its attachments, Your Honor.
And I've gone over that with my client. We have no objection, Your Honor.
Ms. Neely, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 in attachment. To the repeat offender enhancement allegation, how do you plead? True or not true?
Sure.
And the court will review states exhibits 1 in attachments. Oh, I guess I should have just paid attention to the arrow.
That was for previous by the state, Your Honor. Observing this. Okay, sorry, try that.
Oh, no problem. All right, after reviewing states exhibits 1 in attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and also based upon states exhibits 1 in attachments. Are you proceeding with sentencing?
Yes, Your
Anything you wish to say on behalf of your client?
Your Honor, my client's taken responsibility. She also has a federal case that she has to take care of. And when she finishes her sentence on this case, she'll be going there. So we'd ask for credit for time served.
All right, and is the felony case, I'm sorry, is the federal case still pending?
No, it's, she was on, supervision, so it's gonna be revoked, I believe.
All right, I mean, I could ask that this run concurrent with that.
If there's a
but,
way to make that happen, that would be excellent. We would ask for that.
I can tell you because I guess technically you haven't been revoked on the federal case, even though I say run concurrently. It's really up to them whether they will do it or not. Do you know what the case number is?
We don't know.
All right, if the court is,
It's like the different cases.
all right, the court is given the case number, the court, of course, will add that and have it added into the judgment. But for now, the court is just ordering that it run concurrent with the federal case. All right, is there anything else for me to decide with regards to sentencing?
State, Your Honor.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. What are you planning on doing with the rest of your life? That's something that you need to be thinking about, unless you want to be the person who, when somebody comes to some institution, says, how does this place work? And they say, oh, you need to speak to the oldest person here. And they say, who is that? They're like, oh, we call her Grandma Antoinette. Or either with you, they may say, we call her Queen Antoinette because of your middle name. And then you find out you're the oldest person at the prison. So you had better start making changes because it's not going to go well if you don't. You understand? All right, good luck to you. Thank you, Mr. Cohn. All right, the people that we'll meet back are Trevina, Samantha Richards, Juan Rachana, Philip Diller, and Juan Avalis. And who is the person who's charged with the failure to register? Oh, that's Bolden. All right, and Mr. Bolden. So those are the people we need back, and anyone else. Let me see, who does that remain on the list? Is that the only people who are on the list? Yeah. Yes, I did. All right.
Tomorrow night, Andrew?
No, we're coming back this afternoon at 1:15. Yes. All right, everyone. So for those whose cases were not taken care of, who are you with, Mr. Cabanas? All right, 1:15. Everybody, 1:15. And on. All right, and Scott, Marcelio, Scott, you need to be back at 1:15 as well. And hang on to Mr. Raymond Ruiz.
Said before that I was going to start, so we come back at 1:15.
1:15.
Your Honor, can I get that order time just so that I can bring it for me?